launch.
Welcome, everybody. Planet Green Trees. This is the show you're listening to. We are Michigan's Blog Talk Medical Cannabis premier radio show. I'm your host, Michael Komorn, and this is officially episode 149. We are calling it MSC, Michigan Supreme Court, People versus Koon. I don't think there's anything else that can really be spoken about. It's a significant moment in the history of Michigan statutes, of Michigan laws, of the way in which laws to be interpreted, and for medical marijuana patients. So we're calling it People versus Koon. We're going to be talking about that throughout the show. Today, of course, is May 23rd, 2013. The call number is 1-347-326-9626. Dial 1 to get on the air if you want to be heard and participate in our little radio show we have here. Tonight on the show, we've got renowned author Steve Elliott, who owns and edits the independent cannabis blog, TokeSignals.com. He's a marijuana reviewer for the Seattle Weekly, editor of Hemp News, and is a national news columnist for Northwest Leaf magazine, and also the author of The Little Black Book of Marijuana. He's going to be calling a little later. We're going to hear his thoughts on what's happening at the national level, as well as specifically in Washington, Seattle, and other areas in the Northwest that he's been covering. Also, the spotlight on our organization, Michigan Compassion, which is the state's only federal recognized 501c3. What a fun time to talk about IRS nonprofit statuses and whatnot with the purported scandals happening at a federal level. This specific organization, Michigan Compassion, nonprofit dedicated solely to the medical cannabis education and advocacy. The organization is one of only 4 in the country to be granted this nonprofit status. As I said, we're going to be discussing the Supreme Court decision of People versus Koon. Just a brief backdrop, the Michigan Supreme Court issued a unanimous opinion making a finding that the Michigan Medical Marijuana Patients are protected against the charges of any presence of a controlled substance and requires evidence beyond just the presence of the THC in your bloodstream. We're going to talk about that throughout the show, but that's the teaser. Also, the Bob Redden case and Tory Clark resolved itself last week, and we're going to be talking about that as well. And what a good way to transition into one of our in-studio guests, my good friend and cannabis warrior, David Radoy.
Hello, hello.
Welcome to the show, and thanks for being here tonight.
Thank you. Always happy to be on the air with you.
Got a lot of good stuff to talk about. We're going to be interested in hearing your legal thoughts on that. Also in the studio with me is Chad from the Birmingham Compassion Club.
Good evening. It's nice to be here.
Chad, thanks for being here tonight. Good stuff. We're expecting, of course, Jamie Lowell, producer from Third Coast Compassion. I understand we have Rick Thompson calling in, and he will be delivering the news. Tonight's show is sponsored by the Michigan Medical Marijuana Association, MichiganMedicalMarijuana.org. I want to thank all the moderators and administrators at the site who assist in keeping that environment and the forums a safe environment for people to engage in the discussions of medical cannabis and evolve the conversation. Komorn Law, 1-800-656-3557. The Med Joint Community Compassion Center in Ostemo, Michigan. Our good friend Kevin Spiller, I want to give a shout out to him. Also our friends in Detroit, the Marijuana Rancher. Check out the Marijuana Rancher. He's Detroit and opened recently a cannabis cultural center, I understand. All right, so got a lot of things to talk about tonight, all kinds of legal analysis. We've got codependent attorney in the audience, in the studio here with us, and we're going to begin. But I want to rant a little bit about this case, this historical ruling, People versus Rodney Lee Koon. The backdrop, for those that do not know, involves the following. Mr. Koon was charged in the 86th District Court with operating a motor vehicle with any amount of a Schedule I controlled substance in his body, which is a violation of the 257-625 code. What does that mean? That is the statutory code that prohibits driving when it prohibits specific driving, but in this statute code it prohibits driving with that's affected by or people have the presence of alcohol or drugs. And this statute essentially had been amended in October of 2003 to bring all of the drunk driving charges and all the drug driving charges under one roof, which is now 257-625. And within that, they've got different numbers that specify the prohibited behavior. But at that time, when they amended the statute, what used to be OUIL and OUID and UBAL, first offense, second offense, impaired driving, first offense, all of that was things that happened many, many years ago. But when they amended the act, this law, 257-625, they brought them all under one statute and gave them one particular charge, which is essentially operating while intoxicated. OWI has become known as and unified all of the drunk driving types of charges under one roof. There's a lesser included offense of operating while impaired. If you're talking about alcohol, these charges are misdemeanors for first offenses that carry, in addition to up to 93 days in jail, there's licensing sanctions, there's fines, there's license privilege suspensions and restrictions, there's costs and fines with the driver's license appeal division. But I say all this because this is how the Michigan and its legislature has dealt with driving and individuals being impaired or intoxicated by a substance, all under this statute. But what's gone on in Michigan for many, many years is how the drivers have been treated if it's determined that they have any presence of a controlled substance in their body. Not too long ago, the law in Michigan was even more perverse, you could say, prior to the Supreme Court ruling in People v. Fiesel, which allowed an individual who was driving and had the metabolite of marijuana, not the active ingredient of marijuana, which we know is THC or Delta-9. We're talking about the metabolite, the molecule that stays in your body for some 60, 90, 120, even more for some individuals in your body. So that means that much time after the last ingestion of cannabis, an individual may have this metabolite of marijuana in their body. That used to be a crime. Just as recent as 2008, overturned, maybe it was 2009, People v. Fiesel. But what still existed on the books, has been in controversy, is the following. That the Delta-9 active ingredient of THC, when it is in someone's body and they are operating a motor vehicle, even if they're operating the motor vehicle as any normal, prudent driver would be operating a vehicle, that is a crime. It's a crime in the sense that it punishes not any bad driving. It doesn't punish any swerving, going over the line, unable to operate the motor vehicle in a way that a normal, prudent driver would. It punishes you merely for being behind the wheel and having active THC in your body. It is one of the more offensive crimes that exist, especially in light of the Michigan Medical Marijuana Act. When this, amongst a couple other laws that seemingly are being utilized to punish people, when they become aware to people, they say, what? You're punishing someone who's driving fine merely because of something they have in their bloodstream when there's no evidence at all that it's affecting their ability to operate the motor vehicle? This seems insane. And there's some jurisdictions, I think, that won't charge because they realize that they don't want to punish someone if they're not acting badly. But there's other jurisdictions that have taken it upon themselves to enforce the law. And enforcing the law means that any presence of a controlled substance, that being THC, marijuana, is a crime. And what we've found over the last 3 or 4 years, and I remember the way that this has evolved and when it was turned into a much more pressing issue, was early on when the law had been passed and people would be charged and have less than 2.5 ounces on them in their card, or we'd bring the card to court, the charges were dismissed. There was a grumbling amongst prosecutors that what they're going to start to do now is not charge them for the possession, but when they learn of their patient status, draw their blood. Because we know that if you medicate the night before, even 48 hours before, and you're in a vehicle, you're likely to have trace elements of active THC because that's a level that it's acting medically. I went through this in a trial where I litigated all these issues. And what we learned is that most of the blood draws for people presumed to have medical cannabis in their system are usually around a level of 14, 12, 10, 8, 6 nanograms. Why is that? Because after an individual ingests marijuana, takes the last puff on a marijuana cigarette, or after they eat the cannabis, the levels of their THC are at their highest after smoking, exclusively after smoking. They're at their highest. And immediately after the last puff, they dramatically decrease, meaning the absorption into the body in and out with the active ingredients to producing the metabolites on the other side is much faster than traditionally alcohol. There's a grade that is much more gradually moving up and reaching a peak and coming down for alcohol. Marijuana is not that. Marijuana or cannabis, when smoked, goes straight up, its highest peak, and sharply down within the first 20 minutes after the last puff. So says the science, your THC levels are going to be at a level that's somewhere around 14, 12, 10. And that is what the numbers show, that if you see any of the blood draws, they'll reflect those kind of numbers. And the question is, what is that number? What does it mean? And but again, there's trace amounts that we've seen with law. In fact, Rodney Koon was 3 nanograms, I think.
You know, I was always more concerned with the effect of ingested cannabis.
We'll talk about that.
Because that tends to keep that consistent level in the bloodstream at all times, even when one is not impaired.
I would agree. And the point that I'm trying to make is that at that level, and I remember this, cross-examination of a prosecutor with an expert in a case that was testifying about impairment and whatnot, and the question that was asked was like, with 8 nanograms, expert, isn't it true that the driver was affected by those levels of THC? And the expert said, sure they were. Their pain was probably reduced. Their nausea may have been reduced. Their whatever their medical condition may have been reduced, but affected by in what way? And the point that I'm making is there are medical levels of THC that people are going to have in their system because the way their body metabolizes it and the way in which, depending upon the amount that they ingest and how frequently they ingest. But the point is that this was an existing crime in Michigan, punishable as if it's the same as a drunk driving crime, and it's merely for having any active ingredient of THC in your system. But I want to make this point, that an individual driving in one lane who's got active cannabis 9, 12, 15, and is driving perfectly normal next to a driver that when pulled over blows a .17 on the breathalyzer, that crime is equally charged, same punishments, same effects in terms of your driving record. If you pick up any other kind of alcohol or drug-related driving offense within 7 years, you mandatorily lose your license. Mandatorily. 2 convictions within 7 years for any of these crimes outlined in the 257-625 that I talked about. So picking up a crime and a conviction for a driving offense for any presence and getting something else in 7 years bans you from driving. And the only way you're going to get it back is to prove to them that you don't have a drug or alcohol problem, and using cannabis is considered a drug or alcohol problem. So do you see the cycle that's going on there? Do you see the direction that it goes?
Now, that's still what's going to happen, but they now have to prove impairment.
All right, I'm going to get to that. So this is a historical moment in the medical cannabis community because it's the first time since its enactment that the Michigan Supreme Court found specifically that the Michigan Medical Marijuana Act superseded another existing prohibition or law. What does that mean? That means that despite all the things that I've said and the fact that they are punishing in the statute an act that you cannot put a finger on bad driving, those are not the reasons that the Supreme Court came to the conclusion. Instead, they looked to the simple reading of the law. I got to tell you, for 4 or 5 years, I argued about this Section 7E. It seems like a very powerful statement.
Yay, 7E.
Any law that conflicts with this law shall be trumped by this law. Something that, what is it? You got the exact words there, Dave? But that's the gist of it, that when laws become in conflict with the Michigan Medical Marijuana Act, because of the newness of it, place and time, let it be known that this law will override and supersede whatever law is in conflict with. So you would think, when you find yourself in a Michigan medical marijuana potential defense for being a patient and being protected from having any presence of a controlled substance, you would think that the Michigan medical marijuana would supersede. That didn't happen. In fact, just the opposite happened.
all other acts and parts of acts inconsistent with this act do not apply to the medical use of marijuana as provided for by this act.
There you go. One of the things that was tied into this, unfortunately, was in Section 7, the prohibitions from being allowed to assert a Section 8 defense. One of those potential behaviors is driving while impaired. So we know that the Michigan Medical Marijuana Act specifically prohibits an individual from being impaired by marijuana, affected by its ingestion, and getting behind the wheel.
Operate, navigate, or be in actual physical control of any motor vehicle, aircraft, or motorboat while under the influence of marijuana.
There you go. Meaning, the only way you can read that statute, that section, is that the cannabis that someone has ingested was directly connected to their ability to operate the motor vehicle. This crime, any presence, zero tolerance, does not fall into the prohibitions of the Michigan Medical Marijuana. It's something else. It's something well beyond, something that I would suggest the voters of the state of Michigan intended to protect for, especially when there's no evidence of anything bad taking place. So I think one of the most significant things about this historical ruling, which was unanimous opinion, by the way, was that they acknowledged for the first time the power of the Michigan Medical Marijuana Act, the intention of the voters, the shield that it was intended to be, the protections that it was intended to afford individual patients from their medical use of marijuana, assuming that they're not doing something else wrong. And by just being a patient and not driving badly with no other evidence against an individual is not going to be a crime that's going to result in an individual being charged. Now, what we know is that the case goes on to say that other evidence would be required. What does that mean? That means they're going to try to make the connection of your driving, whatever it may have been, with your ingestion of cannabis. They will still probably draw your blood. And they will try to make the case down the road that this level somehow directly impacted the ability of the individual to drive. There are no numbers like an alcohol of a .08, which is presumptively intoxicated. There are no, and Colorado's gone through a couple attempts to legislate that. This is a very difficult thing to accomplish just because of the many, many complex varieties and factors that would go into being able to even come up with what that would be.
It has to be higher than .05.
For certain. I mean, it's got to be something, yes. And I'm not even...
But it's, right now where the law stands is that, you go by the law for under the influence of alcohol if they don't have a test, which requires proof that the person's ability to drive is substantially and materially affected. That's the actual case law. And then I also have a quote, Black's Law Dictionary defines under the influence as deprived of clearness of mind and self-control because of drugs or alcohol. So those are pretty tough standards to prove without the test. And the test will only be evidence of being impaired, but they have to prove that that substantially affected the person's driving. So there has to be bad driving. I think this is going to increase the use of the DRE,
yes,
drug recognition expert, voodoo.
And let's talk about that, and then we're going to go to a break and come back and get it on with our guests and whatnot. But the question is, what's going to happen next? And David referred to DRE, drug recognition experts. This is something that's been developing in the law enforcement community where they send police officers to a couple of days of training, and they come back and they can then have the individual suspect perform certain tests and draw conclusions of their actual impairment or effect that a specific drug may be having on them. It's very, very powerful evidence. I think it's junk science, but is powerful in the sense that juries tend to believe experts, and if they're qualified as an expert, they can directly make the correlation between the observations and their testing as an expert and that they're under the influence. That is the direction I see this going. But at the end of the day, it's an important victory. I think that, why I think it's most important is that this crime, as it stands, is a strict liability crime. You can't even argue that the person didn't know or realize. I mean, it is, and therefore it is. It's hard to defend. You either have to defend the old law by making the case that the numbers provided by the state of Michigan are inaccurate, the state lab, whatever their levels of nanograms of THC, that's inaccurate. That's one argument. Can't prove that beyond a reasonable doubt. Or be able to argue some of this, but the jury instructions for that crime don't allow for it, and it's a difficult case, and people know that, and they've been, but by no means still winnable. Don't get me wrong, but I'm just saying challenging across the state. But with that being gone now, and the need and necessity to prove some direct impact of the cannabis on the person's ability to function normally, operate the motor vehicle normally, or being affected with their normal, cognition or ability to act like a prudent driver, this is not something that's going to happen easily. I think that generally, unless there's really evidence of specifically bad driving that can be associated and attributed to the use of cannabis, and those are tough things to even factually determine, right? Like, how do they really know when someone used it?
Is it going to be judges making this determination in most cases, like in district court?
It'll be jury questions. They will be all jury questions. Defendable.
In district court or circuit court?
Depends. There'll be felony. You get to felony court if someone's charged with a third offense. If you've got 3 within your lifetime, any 3. If you have 2 priors and you're charged with a third, and it's any of these alcohol-related or drug-related driving offenses under that 257-625, you're going to be defending yourself in a 5-year felony in circuit court. All right, so that's the rant for now. I think we can talk a lot about this. I know that there's a lot of material to cover in terms of the implications of it and what it's going to mean for the future, and maybe we can even talk a little bit about what patients can do to try to insulate themselves from falling into these kind of charges. But we have, of course, Steve Elliott calling in. I think we'll get some calls from our contributors, being Rick Thompson and Jamie Lowell. And you're listening to Planet Creatures. The call number is 1-347-326-9626. We'll be right back.
Look at me now, I'm all dressed up in your words today. Do you think about me? What do you think about me? And if it comes down, it's